I'm just going to start with a little discomfort. We're supposed to be talking about faith communities, and I have a bit of a problem with the term faith communities in general. But it's supposed to be a broad topic, and we seem to have not talked about anything except Muslims. And I think that really is quite problematic. I'm now going to talk for 15 minutes about Muslims, but you know, hey. I start also with another apology. I'm going to argue strongly against essentialization, but use many sweeping and polemical statements in the process. I'm going to do that partly because of time constraints, and if anybody would like to have a sort of more nuanced discussion with me, you know, most welcome to take that up. So let's see how we go. The question of, and I've called this how to have our cake and eat it, women's quest for justice and equality in the family in Britain's Muslim communities. So the question of how to advance family rights, family law rights of women in Britain's Muslim communities is bound up very closely with the problems of racism and sexism. It touches upon some of the very big binaries in public policy and sociological analysis. So universalism versus cultural relativism, individual versus collective rights, rights versus culture, and so on. This is often reduced to a question, and you see this a lot in human rights discourse as well, the sort of human rights standards field, of how to balance rights and culture. How to ensure ethnic minority women get their culture, but not too much of it because that's bad for them. So I'm going to make 4 broad points here. First, the discussion of what's mistakenly called Sharia law and Sharia councils and religious arbitration in Britain is founded on gross misunderstandings about formal and informal law in Britain, and misinformation about Muslim family laws here and globally. Second, that the claims and counterclaims of all parties to this debate are founded on a significant lack of empirical evidence, both quantitative and qualitative. Third, that plural legal systems are neither the ultimate solution to the lack of access to justice for minority women, nor are they the embodiment of all legal evil. And fourth, I'm going to provide, rather breathlessly because of time, suggestions for some constructive approaches to considering culture and women's rights. So first, the misunderstandings about this thing called Sharia law, Sharia councils, and so forth. Progressive, and that's a hugely debated term, but let's just go with it. Progressive Muslim theologians and scholars, men as well as women, both in classical times as well as in today's highly animated debates, have pointed out that while Sharia, which is the sort of general path outlined by God, is divine, its interpretation in the shape of concrete laws and rulings that govern our daily lives is most definitely human. That interpretation is highly contested and diverse across time and geography. Polygamy is just one example. So, for example, in Tunisia it's been banned since 1956 under an interpretation of Quranic verses. It's freely permitted in the Gulf states, and in Pakistan, Malaysia, and the North African states, it's subject to certain conditions under law. If everything were agreed and crystal clear in the holy texts, then there wouldn't be 22 different laws in 22 different Muslim countries that the International Network, Women Living Under Muslim Laws, found in its 10-year research on women and law in the Muslim world. So it's all a matter of human interpretation. And when humans get involved, there's power, contestation, politics. Thus, the interpretations of, for example, women's right to divorce by the Sharia councils here in Britain must be seen as an ideological statement. Having married and divorced in Pakistan, having edited the international synthesis out of Women Living Under Muslim Law's research program, and having assisted dozens of women in crisis in Britain who've interacted with the Sharia councils, I can very confidently state, here comes the polemic, that Sharia council interpretations here are among the most conservative and gender discriminatory in the world, and I really mean that. Although I'm not today speaking as a representative of the Muslim Women's Network UK, I can tell you that Muslim women in Britain today are waking up to the fact that what they've been told is correct Islam is decades, if not centuries, behind the experience of their sisters in other Muslim contexts, whether working from within the religion or working from non-religious perspectives. And the women here are asking, why is this? The uncomfortable answer is that their community leaders and the successive British governments that have promoted them do not see women in Muslim communities in Britain as having the same rights to equality as other citizens. They just don't see that. So Muslim laws are not divinely ordained, and most Sharia Council members have a discriminatory, largely right-wing agenda. Unfortunately, not only do most Muslims and non-Muslims in Britain believe that the discriminatory position is ubiquitous and divinely mandated, most Muslim and non-Muslim members of the public, many policymakers, and even some rights activists are also thoroughly confused about the actual legal status of decisions by Sharia councils. Sharia councils are not courts. We shouldn't call them courts. Their decisions have no legal validity in this country. Indeed, their decisions carry no weight even in Muslim jurisdictions abroad. So, for example, a British civil divorce is a valid divorce between Muslims in the eyes of Pakistani law. Okay? I want to make that quite clear. A pronouncement by a Sharia council in Britain would be litigated up to the Supreme Court in Pakistan and probably wouldn't be accepted, politics depending. Iran's courts, for example, require decisions by any forum to be validated by an Iranian court. So these decisions here don't have any validity under English law. They also have very dubious, if marginal, validity in Muslim jurisdictions. Only one or two, the only decisions by non-Muslim state forums in this country that have some validity under English law are decisions by forums set up, or arbitration agreements in forums set up under the Arbitration Act. But there's only one or two tribunals that have been set up by Muslim organizations, possibly a handful. Actually, understanding how many is very tricky. And the law doesn't allow them to hear marriage and divorce matters. So arbitration tribunals can't hear marriage and divorce matters. The fact that they do is a separate issue. Okay. So this brings me to my second point, which is the significant lack of empirical data. No one knows how many women in Britain there are who are in these unrecognised marriages, so-called nikah marriages, where no civil ceremony has happened. No one knows what the percentage of women in Muslim communities is that only seek relief through the civil courts. We seem to ignore those women altogether. What percentage approach both the formal and informal courts? No one knows how many polygamous marriages there are. No one knows conclusively why women approach Sharia councils in the first place. Is it deeply held faith? Is it misinformation? Is it community pressure? All or none of these. No one knows what the major reason is that women, often highly educated women, born and brought up in this country, even agree to these unrecognised marriages. Is it that they're promised a civil marriage later and then they're too invested in the relationship to challenge that? Is it because of some misplaced belief that nikah is the proper Muslim way? We don't know. We all speak anecdotally, which is fine, but it's a very poor basis for public policy.